Welcome to the Supreme Court of the United Kingdom, where today and tomorrow we're hearing the appeal in the case of Manchester Building Society and Grant Thornton, a case in which the Building Society is seeking to recover damages from the respondent firm of accountants for professional negligence. The legal point in the case concerns an issue in the law covering the recovery of damages. Details of the case can be found on our website by going to the link to cases and then to current cases. I'm hearing the appeal with 6 of my colleagues, whom I'll briefly introduce now. First, the Deputy President of the Court, Lord Hodge. Lady Black, Lord Kitchen.
Good morning.
Lord Sales.
Good morning.
Lord Leggett.
Good morning.
And Lord Burrows.
Good morning.
Counsel for the Building Society will be addressing us first. That's Ms. Rebecca Savin-Clare, Queen's Counsel, and I'll invite her now to begin her submissions.
Thank you, my lords, my lady. As you say, my lord, I appear on behalf of the appellant, and I appear with Mr. Parker and Mr. Wright, appearing for the defendant auditors, the respondents, and Mr. Salcedo, Mr. Rushworth, and Ms. Shaw. The central question raised by this appeal is as to what facts have to be established by a claimant in order to recover damages for breach by a professional of duties which they have assumed by contract. That's not at all to say that this is an appeal on fact. Quite the contrary, the appeal raises a question about what legal test has to be satisfied by a claimant. I'm going to start by making some introductory remarks to introduce the issues. Then I'm going to set out my stall with a map for the rest of my submissions. So, my lords, my lady, as you will have seen, the Court of Appeal and the trial judge, though for different reasons, both held that the Building Society's claim for the cost paid to exit certain swaps in June 2013 failed as a matter of law because, they said, the Society had not established that the loss was one which fell within the scope of duty owed by the defendant auditors. The Court of Appeal held that this was an information case, with the result that only losses which would not have been suffered if the information had been correct were recoverable. And I'd like, please, to take you directly to what we suggest is the central paragraph of the Court of Appeal judgment. You'll find that at page 124 of the bundle. I'm giving a reference there to the electronic pagination. Page 124 of the electronic bundle. And we're in the judgment of Lord Justice Hamblin at the bottom of page 124, paragraph 88, where he says, in my judgment, these considerations show that this is a case in which, in order to prove that it would not have suffered the MTM losses if GT's advice had been correct, MBS had to do more than establish the fact of the MTM losses. It also had to prove the counterfactual, namely that the loss would not have been suffered had it continued to hold the swaps. And they say this is an aspect of proof of loss. It is not a matter of avoidance or abatement. The crucial words there are had to prove the counterfactual, namely that that loss would not have been suffered had it continued to hold the swaps. The MTM losses they're referred to were money paid to exit the swaps prematurely when it came to light that the Society could not apply hedge accounting. And it was, and it is, see paragraph 22 of the Statement of Facts, common ground that that money would not have been paid in June 2013 had the advice on hedge accounting been correct. Wouldn't have been paid then. So what paragraph 88 of this judgment meant was that, according to the Court of Appeal and applying its test to the facts of the case, in order to recover damages for a foreseeable loss, which would not have been suffered but for the negligence, and of which the negligence was an effective cause, my clients had, they said, to go on and prove that they would not have suffered an equivalent loss at some other time had they continued to hold the swaps. That's what that test actually meant on its application to the facts. Now,
I'm sorry to interrupt you so early. I'm getting
not at all.
feedback.
Questions are welcome.
But it might be helpful if you could explain to us why the negative value of the contracts is characterized as a loss.
Yes, well, I am going to come and explain the facts quite fully. I'm going to come to that because that is essential.
Well, I'll be patient in that case.
Well, I want to answer that question straight away because it is fundamental to the appeal. What the hedge accounting meant, what the advice meant, was that there was an effective hedge relationship. The advice itself entailed that the relationship had been effective and, critically, that it would be effective in the future to the term of the swaps. Mr. Justice Tier explained that that's what the accounting principle meant in paragraph 15 of the judgment, as we'll come on to see. So, and as I say, this is common ground. It says so in paragraph 22 in the statement of facts. What would have happened had the business model continued, had it been correct that the society could pay hedge accounting, is that 6 monthly payments, netting payments, would have been made under the swaps, and there would have been income from the mortgages. And I've really put that the wrong way around because the mortgages come first, the swaps enable the mortgages. So there had been, and there would have continued to be offsetting payments as between the mortgages and the swaps. That's what the hedge accounting relationship was. That was what the accounting relationship meant. Now, true it is that the MTM losses there referred to in the judgment were an amount quantified by the market value of the swap at the time of the breach. That's right. That was the market's forecast then of what would be paid over the term of the swap. But that was a sum to which the society would never have been exposed had the advice been correct. It would never have been exposed to it but for the negligence. It would not have paid out that sum. So, my lord, to come back to your question about why paying the negative value of the swap is a loss, the reason for that is perhaps twofold. One is that the idea of the swap as an asset at all is itself a misconceived one with respect, because this was a business model with offsetting swaps and mortgages. And secondly, because it's one side of the coin, and if one's considering what would have happened if the advice had been correct, you also have to consider the mortgage income that would have been received. So
I think you may have to go into this in greater detail.
I will do. I will do. It's obviously an important point because we do say that the Court of Appeal failed to understand this, and that led them down the wrong track. Yes. But perhaps before moving on, I can also plant this thought that in any event, all that the MTM can be said to have been is an estimate of what would have been paid in the future under the MTM losses. It is not a sum that would have been paid if the advice had been correct. So it looks to the future and it goes to this question, would an equivalent loss have been incurred in future in the same amount. It's not the same loss. It really can't be said to be the same loss because it's not an amount that would have been paid out then.
Well,
so at most it is part of the equation. Yeah.
I'm not sure if your point is simply that it wouldn't have been paid out as a lump sum, but would have been instead a matter of periodical payments over a long period of time.
Yes, I am making that point, but the periodical payments would necessarily have been different from the amount forecast because it was a forecast, and who knows what interest rates will actually be in 2058, which was the time at which many of these swaps were going to expire. So, so at most it was evidence before the court of what would have been paid out in future by way of periodical payments. Well, but as I say, that was only one side of the coin. So I've really got 2 points. One, that it's not the same loss. And secondly, that even if you're going down the route of considering what would have happened in the future, it's only one side of the coin.
Well, it sounds as though you're accepting that the MTM figure was the best possible estimate of the future periodical payments, the value of them obviously discounted back to the time of evaluation. The point you're making about the absence of counterbalancing payments seems to be a rather different point about the early termination of some of the mortgages.
No, it's not. First, can I stand back a moment and say we mustn't lose sight of the fact that whatever the MTM payment was, it was a loss that would not have been suffered but for the negligence.
Well, that's the point I'm really trying to...
Yes.
I mean, I appreciate it may be best just to wait until you've gone through it in greater detail, but I have to say at the moment, I don't myself quite understand the sense in which this can be said to be a loss. So if you can explain it later on, then that'll be fine.
Yes, certainly. All right. So I was explaining that what the Court of Appeal's test meant, applying its test to the facts of the case, were that my clients had to establish that they wouldn't have suffered an equivalent loss at some other time had they held the swaps, because the MTM payments at most were that assessment of what would be paid in future, and it didn't take into account the mortgage income. Now, Thornton, having made clear prior to the trial that it took the position that that indeed had to be proved, my clients did seek to prove the counterfactual at trial. Just pausing for a moment, because I can see that Lord Reed is speaking on the phone. So my clients sought to prove the counterfactual at trial, and we had scenarios addressing what the net position on the swaps and the mortgages might have been in 2058, 2077, 2099, all on various assumptions about what might have happened in future had tomorrow ever come, which it didn't as a result of the negligence. Not surprisingly, the trial judge held that those necessarily identified possibilities rather than probabilities. That's paragraph 200 of Mr. Justice Tear's judgment. So, my lords, we accept that we did not establish what the alternative position would have been had the advice been correct, by which I mean that we did not prove the negative, that we would not have suffered the same loss through some other route. And if we have to prove that, the appeal will fail But, my lord, we submit, my lords, my lady, we submit that that did not have to be proved, because that is to put on the claimant a burden to prove that there was not a bad bargain, which is the wrong way round as a matter of law, and it is a gross overextension of SAMCO to impose a technical rule which is in practice impossible of fulfillment in a case of complexity concerning a business model that would have stretched far into the future, as this is. So we say that cannot be and is not the law. And we have, as a result of those submissions, both a broad and a narrower case. On our broad case, our central submission is that once a breach of contractual duty to take care in some particular regard is established, the filters which establish legally recoverable loss and strip out irrecoverable loss are and are only factual causation, so but-for causation, would the loss have been suffered if the contract had been performed or the tort not committed? Legal causation, meaning was the breach an effective cause of the loss? And reasonable foreseeability. So in a contractual scenario, more accurately put as was the loss within the reasonable contemplation of the parties. Now, those three tests, factual causation, legal causation, reasonable foreseeability, are in our submission the only true filters governing an ordinary claim for breach of contract under very long established rules. Claims for contractual duties owed by professionals are not in our submission in some form of special category with some additional threshold, even if they include obligations to take care and give rise to a parallel duty of care in tort. Scope of duty is a concept imported from tort. But in our submission, it is simply another way of expressing the legal causation filter in this context. It puts the legal causation question in terms of the nature of the duty. It expresses that question by asking, did the defendant have a duty to prevent this harm? But as Lord Sumption said in BPE, that is the same as asking, did the right thing cause the damage? Did the right thing cause the damage? Now, whether you label that question one of legal causation or scope of duty is a matter of nomenclature, not substance. It's in substance the same thing, and we submit that the society's claim in this action satisfied that test. Did the right thing cause the loss? And the key point here is that the measure of damages for breach of warranty, what would have happened if the warranty had been correct, is not in some way in our submission superimposed on claims for breach of obligations, professional obligations, as an additional test. It certainly doesn't operate to bar recovery on the facts of the present case. Warranty damages are simply not the measure of damages applicable to an ordinary contractual or tortious damages claim. They're not a necessary part of the proof of the liability. The SAMCO cap in our submission is no more than a tool which may assist in some cases in identifying loss which was or was not caused by the right thing, i.e. the defendant's wrongdoing. Now, whether one calls that an analysis of scope of duty or legal causation, as I say, doesn't really matter. It is no more than a tool for identifying loss that is correctly regarded as caused by, so the responsibility of the wrongdoer. It is not a rule of law, so it does not have to be satisfied. The Court of Appeal's judgment at paragraph 88 was wrong. In this case, we say that the SAMCO cap tool was neither needed nor apposite. Grant Thornton's advice was not in respect of a single transaction. It was not fairly characterized as the incorrect provision of a single piece of information. The trigger of the loss was solely the discovery of Grant Thornton's negligence. The nature of the loss was exit costs. And we say that for any or all of those reasons, this was not a case raising equivalent questions to, or perhaps better, analogous to Samco. And I do want to make it clear here that I am not suggesting that Samco was wrongly decided on its facts. Rather, my position is that it was a case on its facts. I also accept that in some cases, considering the question, would this have happened anyway, will indeed assist the court in resolving whether the right thing caused the loss. If the answer to that is that the loss would have been incurred anyway, that may be an indicator, part of the circumstances to be taken into account in assessing that question of effective cause, legal cause, did the right thing cause the loss? But what it's not is a rule of law. A narrower case arises if you're against us on that broad proposition, with the result that Samco is to be applied as a code to the case. In that case, we say first that this was an advice case in relation to the application of hedge accounting, or alternatively, if the information analysis is the right one, so that the cap applies, we say that the loss is recoverable because the society would not have paid the break costs in 2013, the MTM losses, if the advice had been correct. As I've said, that proposition that this would not have been paid if the advice had been correct is common ground, paragraph 22 of the Statement of Facts. But what we then say is that the law does not require a claimant, where the Samco cap applies, information case, it does not require a claimant who's established that it made a loss through a payment which would not have been made if the advice had been correct, to go on and prove that negative, that it would not have suffered a different loss had the advice been correct. That is to impose an extraordinary burden on a claimant who's the victim of wrongdoing, to prove facts which are necessarily speculative. Come back to the point that counterfactuals here had to address the position in 2058, or 2077, or 2099. It's an extraordinary burden, first because it looks to the future and it's speculative, and second, because those facts have never arisen precisely because of the breach. Tomorrow never came for the society because Grant Thornton's advice was wrong. In this case, that counterfactual literally couldn't be proved. The judge was right to say that these are possibilities. Of course, it couldn't be proved what the position would have been net in 2099. And our submission on the appeal is that it didn't have to be proved. Now, I promised a route map. Where I'm going to go next is to set up the factual foundation of my submissions. I'm sorry, Lord Leggett, yes.
That last argument, I thought, both when you made it now and in your written case, might be building up, saying that it was the defendant who had to prove that you did not suffer a loss, because the loss has to be measured by comparison with what did happen and what would have happened if the swaps had not been broken when they did. But in your grounds of appeal, you say that you accept that the burden of proof is on the claimant, and you're not challenging BPE, as I understand it, which said that. Am I correct about that, or is that wrong?
They rise in relation to different questions. So the burden of proof to establish the question, is this a recoverable loss, whatever that test is, I say it's an effective cause test. That's on the claimant. I had to satisfy the court that Grant Thornton's negligence was an effective cause of this loss. And I did satisfy the judge of that, and I'll show you that. And I say that that's all that had to be proved, and that's dispositive. In a situation in which the defendant wants to establish that the loss is irrecoverable because the loss would have, an equivalent loss would have been suffered through some different route, I do say that that is a defendant's burden. I say it's equivalent to the wasted expenditure cases. If the defendant wants to try and prove that it was a bad bargain, a loss would have been suffered anyway at some stage in the future, that is for the defendant. And in that regard, the question who has the burden of proof is put in issue by the grounds of appeal. And you'll see that the issues for the Supreme Court at paragraph 29.2, that's at page 10 of the bundle, include the question who has the burden of proof. Lord Burrows.
Can I just follow up that question from Lord Leggett? Is it then correct for us to understand that you would be challenging at least the statement of Lord Sumption in the BPE case, where he clearly said that the Samco, the burden in relation to the Samco cap, that is the burden of proving the counterfactual, is on the claimant?
What I say about that case was that it was actually one in which the burden of proof didn't matter. Lord Sumption made clear at the start that the facts were established either way. But in any event, what he wasn't dealing with in my submission was the question, whose burden is it to show that some other loss would not have been suffered at some stage in the future? I suggest he wasn't dealing with that. Rather, he was dealing with the question, would this same loss have been suffered at the same time? And I already have my finding on that. I've proved that, so I don't need to challenge that aspect of BPE. The MTM amount would not have been paid in June 2013 had the advice been correct, because the swaps were contracts that provided for 6 monthly payments, and those 6 monthly payments would have continued if the advice had been correct.
Sorry,
But how? Sorry.
can I just? Sorry, Lord Reid.
No, carry on.
I'm not sure I understood your response, and forgive me. But as I understand it, the important point that Lord Sumption was making in BPE was that the Samco cap, which depends on the counterfactual of examining if the information had been correct, would those losses still have been incurred? That burden of proof was on the claimant.
Yes.
Now, the way I've understood, what I'm really asking is, are you accepting or rejecting that?
First, I'm saying that the Samco cap is not a universal rule of law. So it would be wrong to say that a claim fails because you haven't proved the cap, because there are cases to which it is plainly inapplicable. And I say that this is one of them. So my first answer to you, my lord, is that it doesn't arise on this case. You then ask me, do I challenge what is said by Lord Sumption there? And in answer to that, in a case in which the cap is relevant, I would not depart from the proposition that it will be the claimant who establishes that it would not have suffered the same loss at the same time. But we are not here in that territory, so I'm not seeking to challenge that. My point is a different one. We say that the Court of Appeal here extended Samco well beyond anything that Lord Sumption was saying in BPE, because it said your claim fails because you haven't proved what the outcome would have been in 2058, 2077, 2099. That's different.
Well, with respect, I really don't follow that submission. It seems to me that the Court of Appeal was precisely applying the Samco cap. It was asking if the information had been correct, would these losses still have been suffered? And Lord Sumption has told us the burden of proving that is on the claimant, and therefore, in that sense, the claimant has failed. That's my understanding of the Court of Appeal reasoning.
Yes,
Now,
I think.
Now, the first point you came back on, with respect, is a different point. Does Samco cap apply? Assuming, which I think was your last proposition, that the Samco cap is applicable, I'm not understanding your point about burdens of proof, because you either are challenging what Lord Sumption said about who has to prove the Samco cap, or you're not. And I just need to be clear about that.
Yes. The reason for our difference or lack of understanding of each other is what is meant by the word "these losses." Because what I would accept is that where Samco applies, it will be the claimant's burden to show that it would not have suffered this same loss. So applying that to the facts of this case, I had to prove, and did prove, that the society would not have paid 32.7 million to break the swaps in June 2013 if the advice had been correct. That's if Samco applies. But what we say did not have to be proved by us is what the position would have been in the future had the advice been correct. So we say it's a defendant's burden to prove that the loss wouldn't have been suffered by some other means. Sorry, can I just continue for one moment just to draw the analogy with wasted expenditure? So in the wasted expenditure cases, the claimant has to prove what its wasted expenditure actually was. And here for us, that was the MTM losses. And my suggestion is that in BPE, my submission is that in BPE, Lord Sumption was saying that that wasted expenditure has to be proved by the claimant. But my submission to you, and one of the grounds of my appeal, is that the burden of proof is on the defendant in a wasted expenditure claim to prove that there was a bad bargain so that the claimant would have suffered an equivalent loss by some other means had it gone through with the model. And we make exactly the same point here, that it's the defendant's burden to prove that there wouldn't have been some other loss, taking into account the payments that would have been made under the swaps in the future and the mortgage income in the future. Sorry to interrupt you, but I just wanted to complete my answer in case the analogy helped.
I don't think anybody's disputing that the claimant has the burden of proving factual causation of loss. We're talking about if Samco cap applies, that cap means that we are required to apply a counterfactual. The counterfactual is, if the information had been correct, would the loss still have been suffered? Lord Sumption says that that burden is on the claimant, the burden of proof of that counterfactual. It sounds to me as if you are saying that you are accepting that and therefore not challenging what Lord Sumption said, but I'm not entirely clear, I'm afraid. I've spent up too much time, but just so you know, that's my slight concern.
No, thank you. Well, I will, of course, be taking you to BPE, so it may be that the best thing to do is to come back to this when we come to the case with the text in mind of what Lord Sumption was saying there.
Can I just mention that the point I raised with you earlier obviously has a bearing on what you're saying at the moment.
Yes.
I hope you'll come to deal with this.
Yes.
I mean, you're saying the one thing we do know is they wouldn't have borne these break costs in 2013, and it's simply speculation to try to estimate what might have happened or assess what might have happened if these contracts had run their course till well into the much further on into this century. But the MTMs are obviously they're based on the best assessment available of what would have happened, and they're simply arriving at a current valuation of what it's anticipated would have happened if these contracts had run their course.
That's right.
This is why I'm at the moment having difficulty understanding how there's any loss.
But crucially, what the MTMs are is only one side of this coin, because the business model was using the swaps to facilitate mortgage lending. So if you're considering what would happen in the future, you have also to consider what would have happened in respect of mortgages. And that's my point on the speculation into the future. You could only assess what the ultimate outcome of the business model would have been. Was this a bad bargain if you had the mortgages? Yes.
But you haven't, I think, carried out any calculation that brings that other side of the balance into account, have you?
And that is the point of the appeal, my lord. Was that something that had to be proved? And we say it didn't, for both the broad reason that it wasn't a case to which the Samco cap should be applied at all, and secondly, for the narrower reason that we say that even applying Samco and its cap, that didn't have to be proved. So perhaps if I may move on.
I think Lord Leggett has I should say, I don't understand your answer, but I'm not going to push it further. Lord Leggett has a question.
Sorry to keep delaying you, Miss Sinclair, but we do have the other side of the coin, don't we? In that we have what the English mortgages at least were sold for.
Oh,
and didn't the loss occur because your client's hedging strategy didn't work? If it had worked, the mortgages would have had a value that offset the loss, as you call it, on the cost, let's call it, of closing out the swaps. Yes. The way it was meant to work was that there would never be an imbalance, but in fact, you suffered loss because the mortgages were worth, as it turned out at the time when the swaps were broken, a lot less than the swaps. So that means that the hedging strategy was faulty, doesn't it?
The critical words there, my lord, were there should never have been an imbalance. If the hedging advice had been correct, if the accounting advice had been correct from Grant Thornton, there would have been no imbalance. The world in which Grant Thornton's accounting advice is correct is one in which there is hedge effectiveness. Now, I'm very concerned that I've answered.
Accounting treatment doesn't alter the reality. I mean, whether the mortgages were worth more or less than the hedging contract, the swaps contracts, it isn't a matter of accounting. That's a fact in the real world.
Yes, but the strategy was to substitute in new mortgages when the old ones expired. So the problem, and Mr. Salcedo likes this point, he tells you the loss arose from the mismatch. The problem with Tomorrow Never Came is that the society never had the opportunity to earn more income from mortgages, which would have offset the swaps. That's the problem. Now, these are really important points, and I'm concerned that I'm answering a lot of questions without having shown the court the material that I relied on. So if I may, what I want to do now is to move to what was in any event the next section of my submissions, which is to explain the factual foundation of our case, to show you where the findings in the judgment are that we rely upon. And then having done that, I'll move back to my legal submissions, if I may. So, just to be clear, my route map is to deal next with the facts, then to deal with the law, and then I will come back briefly at the end to the two further questions on no loss and the cross appeal. So the factual foundation. We say that the starting point is that on the 5th of June 2013, the Society had 32.7 million in its accounts, unencumbered and available to its use. And by the end of the 7th of June 2013, it had paid out that money as the cost of breaking swap agreements. So had I been opening this appeal 20 years ago, I would have said that the society had written a cheque in that amount. It had the money, had it on the 5th of June, the money went. That payment was its basic loss in the language of Platform Homes and Oyston and NICredit. The money paid to break the swaps comprised the MTM value of the swap at the date of the break cost, plus some relatively small additional penalty transactional costs, which is accepted are recoverable. The MTM is explained in paragraph 9 of the Statement of Facts. It will be 0 at the beginning of a swap's life and 0 at the end. In between, it represents the market's forecast of what will be paid net over the life of the swap. I do stress that point that it's 0 at the beginning of the life of the swap. There is no automatic loss by entering into a swap. The judge made 4 findings, which we say are key to the appeal. They are the first, that the payment out of the 32.7 million was a loss. Second, that it would not have been suffered but for the negligence. Third, that the negligence was an effective cause of the loss. And fourth, that the loss was a reasonably foreseeable consequence of the negligence. Now, I'm going to ask you to turn up the first instance judgment, please, to show you some excerpts from the and also to show you some excerpts from the evidence to see and to understand those findings. And I'm going to start by explaining the facts which underpin them. So first, please, if we can go to page 134 of the electronic bundle. And I'm here at the start of Mr. Justice Tear's judgment. In paragraph 3, 5 lines down, you'll see its main activity, that's the society's main activity, is the provision of a range of mortgage products. Typically, they were fixed term, fixed interest mortgages, but between 2004 and 2009, the claimant acquired and issued lifetime mortgages, which were designed to release the equity in a house. So just pausing there, the main activity was the provision of mortgages. And then you'll see in paragraph 4 that the claimant needed, his word, to hedge its interest rate risk. That's the risk that the variable rate of interest which it paid to acquire funds would exceed the fixed rate which it received from borrowers. And it did so by inter alia purchasing interest rate swaps. The judge put this the right way round. The business activity was the mortgages. The swaps were required to facilitate that activity by hedging the interest rate risk under them. I remind you that the basic position under the Building Societies Act, Section 9A, is that a building society is prohibited from entering into any transaction involving derivative instruments. The society was able to enter into these swap transactions because and only because they were bought for the purpose of limiting the extent to which it would be affected by changes in interest rates. That's section 9A, and you've got that at page 2215 of the electronic bundle, should you want to see it. The point I'm making here is that the society was not in the business of trading swaps. That wasn't why it bought the assets, it bought them to hold them. How did it work? Can I divert you now, please, to page 792 of the electronic bundle? And you should be looking at a page with a diagram with arrows on it. And what you're looking at here is a picture from the defendant's expert report for trial, the expert report of a Mr. Smith, a forensic accountant. And what you see there in the diagram is his representation of how the hedging arrangement worked. Now, Mr. Salcido, in his case, becomes quite excited about my use of this diagram, I'm going to make clear in a moment what I do and what I don't say about it. And I'm certainly not seeking to go behind or beyond the findings of fact that have been made. So for the moment, I just want to use it to explain the movement of money under the hedging arrangement. You'll see the society in the middle, and in the top left, there's an arrow going to MBS savers saying floating interest, LIBOR plus X. That was the money being paid by the society to its depositors. So under savings accounts that it offered, it was paying LIBOR plus a bit. Then in the top right, you'll see LTIRS, that's the long-term interest rate swaps. And in the white, there's an arrow coming into the society, floating interest, LIBOR. So the LIBOR being paid to the society under the swaps and being paid out by the society to the savers cancel each other out. You then have a fixed interest rate payment going from the society to the counterparty under the swaps, and fixed interest being earned under the mortgages. So the society's net position under this hedging arrangement is the difference in margin between the two fixed interest limbs. And we've given you some representative figures in the reproduction of this diagram in our case, 6.5% under the mortgages and 4% being paid out under the swaps. The equity release mortgages earned relatively high rates of interest. So the society makes a margin based on the difference between the fixed interest income and payments out under the swaps, less, of course, its various costs, which will include that X% being paid by way of premium to this on LIBOR to the savers. Now, next, please, if we can go to page 621. This is a sample swap transaction contract. You'll see at the top that it's for a notional amount of £5 million. That is a notional amount. These weren't loan type swaps. They weren't swaps that were loans in another guise and of the sort that have been considered, for example, in the West Deutsche litigation. These are hedging instruments. The trade date is 2008. The effective date is the 12th of May 2008, and the termination date 12th of May 2058. So you see there that this is one of the 50-year long-term swaps discussed in the judgment. In the middle of the page, fixed rate 4.33%. Then second entry under fixed amounts, in the middle of the page, fixed rate payer payment dates, the 12th of November and the 12th of May in each year. And then those dates appear again under the floating rate payer payment dates. And the floating rate option right at the bottom of the page is LIBOR. So this was a contract which provided for 6 monthly payments of, on the one hand, the 4.33% amount from the counterparty, by the society to the counterparty, and the floating rate coming back in, the society receiving LIBOR. Provision for a 6 monthly payment. What you do not see here is a payment of the MTM amount. So reverting to that diagram and my use of it, I don't think we need to turn it up again, but to explain what I say. The point of that diagram and my submission and the reason for showing you this swap agreement too is this. There was not going to be a payment in the amount of the MTM for so long as this hedging arrangement was in place and this swap contract was in place. That wasn't what the contract provided for, and it wasn't the hedging arrangement. There is no arrow there saying MTM payment. But it goes beyond that, and this is the point that we now need to go to. It goes beyond that because the hedge accounting advice entailed that there was an effective hedging relationship. Now, what Mr. Salcido says is that the judge made no finding on what the profitability actually was on that arrows diagram in any given year. And he's right about that. It was amongst the pages of my closing submissions which the judge said he was making no finding on. He didn't make such a finding. Didn't say it wasn't profitable, but he didn't say it was profitable either. Mr. Salcido is also right that the diagram assumes perfect hedging, and there will always be some measure of imprecision as mortgages redeem. But nonetheless, what the diagram illustrates is the way in which the hedging relationship was set up to work. That was its theory. So now I want to turn on to the accounting position and to come back, please, first of all, to the judgment, Mr. Justice Tear's judgment, paragraph 13 at page 135.
Obviously, you would be paying money out on that contract every 6 months for as long as LIBOR was below 4.4%.
That's right, but you will be receiving proportionately more income net from your savers and mortgage offering position for so long as LIBOR is low, because you will be receiving the 6.8% or so income under the equity release mortgages at a time of very low interest rates. Sorry, yes, Lady Black.
Can I just ask you a factual matter which has been troubling me since the beginning of this part of your submissions? You said that in June 2013, the Society had £32.7 million in its accounts, and then it paid it out and it didn't have it anymore. But is that the whole picture? Wouldn't there have had to be some accounting entry for the swaps as a liability at that point?
Yes, but for so long as hedge accounting was applied, that was offset by an adjustment. And the accounting position is actually exactly where I'm going next.
Well,
so,
I was thinking really about your proposition that they had this money. The hedge accounting is a way of looking at it in accounting terms, but in real terms, they had the liability, if it was a liability, that the swaps were going to represent.
Yes, but in real terms, what was happening whilst the hedge relationship was in place was that the society's actual position was the net of that arrows diagram. So for so long as the margin between the fixed rate under the mortgages and the fixed rate under the swaps was it's sufficiently big to cover the costs of the exercise. So in our diagram, it's 2.5% as a margin. So long as you're making enough money on that to cover the costs, you're making a profit, you're not making a loss. And as for the accounting position, true it is that you have to account for the fair value of the swaps, but applying hedge accounting, that is offset by the hedge adjustment, as I'm going to say next. But yes, but there was never a liability to pay the MTM under the swap. That arose as a cost of exit, never a liability under the swap contract to pay that amount. It was the 6 monthly payments. So there wasn't a real liability. And where I'm going now is to show you that there wasn't an accountancy net exposure either. So I think I just asked you to turn up page 135 of the electronic bundle in paragraph 13. In paragraph 13, the judge explains the problem that arose when, upon transition from UK GAAP to IFRS, which was that the claimant was required to bring derivatives such as interest rate swaps onto the balance sheet. And derivatives were to be valued at fair value. which is their MTM value. Thus, he says any change in the fair value of the swaps consequent upon changes in present and estimated future interest failed to be recorded in the claimant's profit and loss account. So with IFRS, that fair value of the swaps that comes onto the balance sheet and changes in the fair value go through the income statement. And as he then goes on to say in the paragraph, that's a problem because, and I'm now 3 lines from the bottom of the page, absent any mitigating measures, the claimant's profits and hence its capital as recorded on the balance sheet would be volatile. The movements in the fair value of the swaps would cause the apparent profitability of the society to go up and down. That has an impact on regulatory capital. That could in turn, as he says, have a detrimental impact, sorry, he goes on to say exactly that, upon the claimant's regulatory capital position. Greater volatility could necessitate an increased amount of regulatory capital. Then, IFRS, however, provided a potential solution to the problem of increased volatility. Entities with derivatives could choose to adopt hedge accounting. Hedge accounting allows the volatility introduced by bringing the fair value of interest rate swaps onto the balance sheet to be offset by allowing an adjustment to be made to the value of the hedged account asset, the mortgage, as shown on the balance sheet. So the hedge accounting was directed to mitigating the volatility. Then the judge explains hedge accounting is complex, strict requirements. 4 lines down. It can only be applied if the hedge is expected to be highly effective. That is, if the hedge is expected to be between 80% and 125% effective in offsetting changes in fair value attributable to the assets throughout the term of the hedging derivative. Moreover, the hedge must be determined to have actually been effective in practice. So at every audit, when Grant Thornton looked at the Society's use of hedge accounting in its financial statements, Grant Thornton was advising that your hedging has been effective in practice, 80 to 125%, and it will be throughout the term of the hedging derivative, throughout the term of the swap. That's what it meant, and it would be effective within that band of 80 to 125%. The judge derived that rule, he took that rule from the relevant standard, IAS 39, paragraph 88. That's in your bundle at page 929. I think we need to turn it up.
But he's not telling us that Grant Thornton gave that advice or that the Building Society relied on such advice.
Yes, my lord, he absolutely is. That was admitted in this case. And I can take you to the pleadings to show you that. Indeed, I am going to ask you to turn up
Well, what it's telling us in the paragraph you've taken us to, paragraph 15, is that is the accounting rule.
Yes, yeah, you're quite right. He's explaining there that is the rule. If you turn on to paragraph 23 of the judgment, page 137, the judge says there that because the trial didn't concern issues of liability, the negligence must be taken from the pleadings. And you'll see there that he sets out our account that the hedge accounting didn't conform to IAS 39 because the rules of effectiveness aren't complied with. And as you see in paragraph 24, that was admitted by Grant Thornton. I'm going to show you some documents on this as well. So absolutely, Grant Thornton's advice was that there was hedge effectiveness. It had to give that advice in order for hedge accounting to be applied.
Well, but the whole point of the case is that they didn't do their job properly.
Yes.
Well,
That's right.
well, so far, I don't see anywhere where giving advice that the hedging was in fact effective in accordance with the requirements of the accounting rules.
Let me show you the standard. That's at page 929 of the bundle.
But that's not going to answer that question.
Yes.
I mean, obviously, the Building Society wanted to be able to adopt hedge accounting. The accountants advised them wrongly that they could. And so they did, until the mistake was discovered. Is there more to it than that?
The Grant Thornton did advise that hedge accounting could be applied. That did entail that there was hedge effectiveness, because that was. Yeah.
Well, that's something they ought to have been checking, but it's quite a different proposition to say that they advised the Building Society that there was hedge effectiveness, and that the Building Society relied on that advice.
Yes.
I mean, you're attributing to the Building Society knowledge of what the details were of the accountancy rules, and telling us that because Grant Thornton gave the green light to hedge accounting, they therefore implicitly gave that advice, which the Building Society then relied on.
My Lord, I'm hesitating only because I'm wondering where best to take you. There is quite a bit of material that I wanted to show you in order to explain to you the advice that Grant Thornton gave and the audit work that they did. Yes, Lord Legate. Sorry, you're muted. Could Lord Legate be unmuted, please?
Presumably, every time Grant Thornton certified that the accounts showed a true and fair view, they were certifying that the hedging was indeed effective and would continue to be. Otherwise, they wouldn't have been able to give that opinion.
That's exactly right. And they additionally gave some advice, specific advice in April. So I'm going to go, please, if I may, directly to the advice and to the audit material. So first at page 608 of
Where does this take us? I mean, are you trying to build a case that the Building Society relied on an implied assurance that the hedging was effective?
My case is that the Society relied on Grant Thornton's advice that they could apply hedge accounting.
Yeah.
I also say that if we have to consider what the position would have been if Grant Thornton's advice had been correct, that necessarily entails that the rules for hedge accounting would have been complied with. And those rules include 80 to 125% effectiveness.
Right.
So, yes. So the points do arise at different stages, my Lord. So Grant Thornton's advice, page 608, first of all. There had been a series of emails, of exchanges between the Society from late 2005 about hedge accounting, because Grant Thornton had told the Society that it could not apply hedge accounting to its 2005 financial statements because it didn't have proper paperwork in place. And at this page, page 608, you have the culmination of those exchanges, which are recounted in the judgment. But on the 11th of April, you have the specific advice under the heading hedge accounting coming from Grant Thornton. I have now reviewed your hedge accounting policy document And I am happy to confirm that I'm satisfied that it meets the criteria set out in IAS 39. So that was the specific piece of advice. Then if we go on, please, to consider the audit, can we go to page 645? This is an extract from the audit files, and I'm taking you here to show you the audit work actually done by Grant Thornton. Here they are checking hedges to match against mortgage products. It's the heading at the middle of the page. And I want to give you an example, please. In the middle of the page, there are two shaded entries, of which the bottom one is Royal Bank of Scotland, swap. Then it says 5,000, but you'll see that's in denominations of thousands, so that's 5 million. From the 15th of January to the 15th of January, 15th of January 2011 to 31. So this was a 20-year swap. And over on the right-hand side, you'll see as at, and the product hedged is lifetime mortgages. So that's an example of a 20-year swap hedged by lifetime mortgages. Then if we go, please, to page 643, again from the audit file, again Grant Thornton's work, fixed rate mortgages designated to be hedged. It's the same 5 million Royal Bank of Scotland hedge with a term of 20 years to the 15th of January 31. It says on the page, lifetime mortgages. Then if you look down the right-hand column, you'll see date fixed rate period ends. And there are dates there from December 2030 to March 2032. But these were lifetime mortgages. So those dates are notional ones. The judge heard evidence about this. What Grant Thornton did was to accept this notional end period for the mortgage, and on that basis said, aha, hedge effectiveness is proved. That was terrible auditing. Grant Thornton was the subject of a misconduct finding from the FRC. It's patently terrible. But that was the way in which the audit work was done, and that was then the basis of the audit opinion, for which we need to go, please, to page 952. This is the 2006 opinion signed in February 2007. It's, of course, in standard form. Under basis of opinion, it said we conducted our audit in accordance with the international standards on auditing. We planned and performed our audit so as to obtain all the information and explanations we considered necessary to provide sufficient evidence to give reasonable assurance that the annual accounts are free from material misstatement. And then the opinion is expressed, in our opinion, the annual accounts give a true and fair view in accordance with IFRS as adopted by the EU. So there was there a representation that the financial statements, which applied hedge accounting, gave a true and fair view of the society's financial position. Moreover, it stated that the audit had been conducted in accordance with the applicable standards. The notes to the financial statements, so also audited by Grant Thornton, include reference to hedge accounting. So at page 953, the next page, you will see at B, the heading Summary of Significant Accounting Policies. And then over at page 954, under the heading Hedge Accounting, the group uses derivative financial instruments to manage interest rate risks. The derivatives are held on balance sheet at their fair values, with changes in their fair value being passed through their income statement. However, by applying the hedge accounting rules set out in IAS 39, the carrying value of the hedged item is adjusted for the gain or loss arising in relation to the hedged risk. This practice therefore considerably reduces the volatilities of movement. To qualify for hedge accounting at inception, the hedge relationship must be clearly documented. At inception, the derivative must be expected to be highly effective in offsetting the hedged risk, and effectiveness must be tested throughout the life of the hedge relationship. So Grant Thornton very definitely was saying, by its audit opinion, that the effectiveness criteria under IAS 39 had been met and were expected to be met prospectively, prospective effectiveness being part of the standard. And just for completeness, at the next page, page 955, you'll see that there were specific figures within the financial statements for the loss from derivatives and hedge accounting. Here in 2006, everything is in its infancy, so the numbers are small. The gain on derivatives was 318,000, offset by an adjustment of a loss of 361 on the mortgage risk, the mortgage interest rate risk fair value, the offsetting adjustment. Those numbers are small because things were at an early stage. The numbers became much bigger. If one looks onto page 958, you'll see the equivalent figures now in 2008, so after the financial crisis. At the bottom of the page on 958, the figures are now a loss on the derivatives of 26.4 million odd and a gain on the fair value hedge accounting adjustment of 26.798. In our case, we set out the figures at paragraph 31.11 for those adjustments in each year, and the reference is to page 38 of the bundle. So whilst the hedge accounting was being applied, what you see from the table at paragraph 31.11 in our case is that the net gains or losses applying hedge accounting each year were small. This adjustment was effective in a non-technical sense. The volatility in the financial statements was very substantially mitigated by applying the hedge accounting. Now, there is no suggestion, there never has been any suggestion, that the Society was incurring losses up to 2013 with this business model. The Society was carrying on very nicely. The judge made no precise findings about profitability or losses on that arrows diagram, but what the Society was very definitely not doing was incurring a loss in the amount of the MTM payments. So whether one considers the position up to 2013 on a cash basis, amounts going in and out cancelling each other out, or on an accounting basis, movements in fair value cancelling each other out, the Society was not incurring a loss in the amount of the MTM swaps. It did not pay out that 32.7 million until Grant Thornton's negligence was discovered. My Lord, that would be a convenient moment to break if it's convenient to the
Yes,
board.
certainly.
Thank
We'll
you.
resume in 5 minutes' time.
Thank you.
We're ready now to resume the hearing in the case of the Manchester Building Society and Grant Thornton. Before you proceed further, can I just ask you just to go back for a moment to explain something to me,
Yes.
Ms. Claire? You took us to page 958 in the electronic bundle.
Yes.
And to the foot of the page, where we saw the loss on derivatives, the change in, which I think is the change in the value of the derivatives in the year 2008, is
Yes.
26 million odds. And then there's an entry for fair value hedge accounting, gain on hedged items attributable to hedged risk, which is a roughly equivalent figure of 26.8 million.
Yes.
Now, is that an increase in the value of the mortgage for the year?
I'm afraid it's more complicated than that.
Right.
It's an increase in the fair value of the hedged risk, which is the interest rate risk under the mortgage. So the interest rate risk to which the mortgage gives rise. So it's not the value of the mortgage itself, which goes through as an amortized cost. It's the fair value of the hedged interest rate risk.
Well, I think I understand the figure for the loss on the derivatives, because presumably in 2008 there had been a steep drop in interest rates, and in consequence of that, the capitalized value of the swaps contracts would have plummeted, because there'd be anticipation of the fixed interest payments out greatly exceeding the LIBOR payments in. Is that right?
That's right.
Now, can you give me at that sort of level of simplicity an explanation of what the gain, the increase in value of the hedged interest rate risk represents?
Yes. If interest rates are at 0.5% or thereabouts, gaining mortgage income at 6.8% or thereabouts is a great deal.
Yep.
So it is related to the value of the mortgages in that sense, but it is more accurate to say that the gain is the fair value of the hedged interest rate risk rather than of the mortgages themselves.
Right. Okay, thank you very much.
Lord Leggett.
Is the problem that occurred because of the disjunction in terms of time? So in that the swaps were for 50 years, but the mortgages were for, let's say, 20 years, or that's what they were going to likely to be. So that if you'd taken the fair value of the mortgages themselves, that would have been quite a lot less than the fair value of the swaps.
Yes.
And when it was closed out, that is why there was a mismatch, because the swaps were discounting interest rates far into the future, whereas the mortgages only had value for as long as they were going to last, which wasn't nearly so far into the future. Is that where this whole problem occurred?
And therefore, because tomorrow never came, the society never had the opportunity in 2035 to buy a new book of lifetime mortgages, or it doesn't have to be lifetime, any form of fixed rate income to replace the outgoing income.
Yeah, so the society's strategy depended on being able to replace mortgages, and as long as the actual interest rates on the portfolio at the time were being hedged effectively by the swap rates at the time, it was never going to have to close out. That was the way it worked.
Yes, well, there are really 2 points. The first is that so long as the interest rates being earned under the mortgages were enough to offset the payments made under the swaps, You were not making a loss. Indeed, you would be making a profit if the margin was big enough. That's the real position, the society's actual income or loss in any given year. And the second is that in terms of the accountancy position and prospective effectiveness, the strategy assumed that there would be replacement fixed rate earnings which replaced the mortgages. And that was exactly the point that I was going to make next, because that is explained by the judge in his judgment. He accepted that Grant Thornton must have given advice in relation to substitution. We can pick that up from paragraph 51 of the judgment at page 144. Where he records that Mr. Nuttall, who was the Grant Thornton engagement partner at the time, had been asked about his recollection. And you can see from the paragraph above, this is all about substitution. And he says in the last 5 or 6 lines of this paragraph, the judge says that Mr. Nuttall agreed that it was possible, and in truth, he'd got no recollection of the discussions. It seems to me, having regard to the passage of time from 2006, that this is very likely to have been the case. I can therefore give little weight to his evidence in his statement that the claimant had been told that substitution was not possible. And then going on to paragraph 54, again, more discussion of the evidence on substitution, concluding thus, although it appears likely that the issue of substitution was raised on the 1st of February 2006, Mr. Nuttall, when he reported, did not say that the practice was a problem. Then in paragraph 59, there's a reference to reusing swaps, and in paragraph 60 to Mr. Nuttall accepting that hedging arrangements could be reused. So, and then this whole passage concludes in paragraph 71 that the judge thinks it likely that the claimant's intention to hedge lifetime mortgages by long-term swaps of 50 years duration had been disclosed to the defendant before the 8th of May, and that was probably during the discussions about the policy, which culminated on the 11th of April 2006. So this was one of the limited areas of factual dispute at the trial, and what the judge accepted was that Grant Thornton had been aware from the start that the strategy was to use the long-term swaps to hedge the risk under the fixed-term mortgages, and that necessarily entailed substitution. That's the effect of these passages. I'm afraid they do rather need to be read as a whole, but that is the effect of what he was saying there. Now, I want to take you now, please, to page 498 of the bundle, because I've explained now what the hedging arrangement actually was, and I want to make good my submission next about Grant Thornton's duties and Grant Thornton's breaches. And all of that was pleaded. Actually, first, if I can take you to page 493. There's a heading on page 493, duties as auditors, and the paragraphs that then follow set out fairly standard stuff that as auditors, Grant Thornton had to report to the members to give their audit opinion. And you'll see in paragraph 54, the plea of obligations to conduct the audits in accordance with the applicable standards, the ISAs, to understand the accounting systems, to understand the accounting policies, to evaluate the appropriateness of the accounting policies. And in paragraph 56, there's a specific plea in relation to the hedge accounting policy. All of this, paragraphs 51 to 58, were admitted by paragraph 39 of the defence. The reference to that is page 540 of the bundle. Coming on then to breach. That is pleaded from paragraph 64. And you'll see there the specific pleas in paragraph 64 that Grant Thornton were in breach by signing the unqualified audit opinions, by failing to report to the society that its use of hedge accounting was not in compliance with and permitted by IAS 39, and by failing to report that the financial statements were materially misstated. And in particular, that's because the full volatility of the movement in fair value of the swaps should be accounted for. Again, all of this, and by all of this, I mean this section on pleas of breach, was again admitted by the defence, and the reference to that is paragraph 44 of the defence, which is at page 541 of the bundle. So the scope of the duties in the sense of what the duties were and the breach of the duties, all of that you find here in the particulars of claim, and all of that was common ground, at least in all material respects. So let's come back, please, to Mr. Justice Tear's judgment and to page 162 of the bundle.
Before we look at that page, can I just ask you, did his focus in paragraph 23 on page 137 wasn't on paragraph 64 at all, but on the allegations of fault in paragraph 62 and 63?
I'm so sorry. I think I'm looking at a different page. I've turned to the electronic bundle. I may be at a different paragraph. Would you mind just giving me the reference again?
Yes, it's in the Mr. Justice Tear's judgment, paragraph 23.
Yes. Yes, he's there referring.
The respects in which the defendant was negligent must be taken from its pleadings, and he refers to paragraph 62 and 63, and then the defendant's response to those allegations.
Yes, he's referring there to paragraph 62. If you turn to page 496 of the bundle, you'll see the heading there, breach, above paragraph 60. And then the first subheading dealt with the hedge accounting policy and the problems with the hedge accounting policy, of which the first is lack of sufficient similarity to be effective.
Yeah.
So
yes, I think the answer to my own question may be paragraph 26 of Mr. Justice Tear's judgment.
Yes, thank you. I'm sorry, that is the shorter answer. But the important point here is, and thank you for highlighting it, that there are two different sets of allegations of breach. These extensive allegations of breach in the bundle, which actually start at paragraph 60 of the particulars of claim, none of that was contentious. So staying in Mr. Justice Tear's judgment, can we turn please now to the findings about what happened once it was appreciated that the society could not apply hedge accounting? And these start at paragraph 115 at page 162. And you have the heading above paragraph 115, the discovery of the error and the events thereafter. Paragraph 115 explains that Mr. Bartlett, who was a new engagement partner, suggested that hedge accounting might not be applicable. PwC gave a second opinion and they agreed. 4 lines down. The consequence was that the claimant did not have sufficient regulatory capital. It was required to have regulatory capital of over 51 million, but its restated accounts without hedge accounting stated that its capital was only 36.7 million. And the reduction was almost entirely because instead of a loss from derivatives of 855,000 in the original 2011 accounts, the loss in the revised accounts was almost 27 million. There were actually two points there. The regulatory capital required was greater because of the volatility to which the society was exposed, and the amount it had was less because of the assets stripped away without the hedge adjustment. The judge then explains in paragraph 117 that Mr. Harding, a newly appointed chairman, considered that the preservation of the capital was the claimant's first priority. He resolved that it was necessary to break the swaps to avoid the risk that further adverse movements in future interest rates would take away even more of the claimant's capital. So Grant Thornton's advice on hedge accounting meant volatility mitigated. Problem, when it's appreciated that that is incorrect, volatility. Mr. Harding resolves that the swaps have to be broken. And then in paragraph 119, the board authorised Mr. G, who was the financial director, to close out the swaps. They were broken on the 6th and 7th of June 2013 at a cost of some 32.7 million. Then at the very bottom of that page, there's a heading, the individual heads of loss. And if you turn on to page 163, you see the next heading, the cost of breaking the swaps in June 2013. And the judge records that there's no dispute as to the quantum of the actual break costs. There was 32.7 million. He then records there was a small dispute about the quantum of the penalty element, which he went on to resolve. Then in 123, he says, as a matter of analysis, the parties have considered the recoverability of the break cost by asking 4 questions, the legal test that he then identifies. So the judge was clear, and he was right, that paying out 32.7 million is a loss. There was no prior liability to pay that sum. It had now had to be paid because of the lack of regulatory capital, the volatility problem to which the society was exposed.
Well, he was told us that effectively Mr. Harding took the view that they had to cut their losses to avoid the risk of further adverse movements in future interest rates. In other words,
no,
things could get even worse.
No, my lord, it's not cut my losses. It's avoid future adverse movements in the fair value of the swaps that creates a greater problem with volatility.
Well, would take away even more of the claimant's capital.
Yes, but it takes away capital because of the accounting entry for the fair value of the swaps. It's really important here that nothing has fundamentally changed in the business model. The accounting treatment doesn't change what's actually being paid out by the society and coming back into it again. But what the accounting treatment meant was that the society had to account in its income statement for the whole of the movement in fair value of the swaps without an offsetting adjustment. And because of the way that the accounting rules work, that meant that the society's reserves were impacted because of the movement in regulatory capital. And therefore, there was a problem. And the risk that Mr. Harding was concerned about was that that was going to get worse. Now, that is set out in the judgment, and I'll come on to show you exactly what Mr. Harding is recorded by the judge as having said. But following this through in the order of the judgment, the place the judge went next was for the but-for test, and he records in paragraph 124 the claimant's case that but for the negligence, it would not have entered into further long-term interest rate swaps and would have closed out the swaps it had entered into before April 2006. And of course, we accepted the burden of proof on that. And in paragraph 127, he accepted that case. So he says, and I'm 3 lines down in paragraph 127, but given that long-term swaps exposed the claimant to the risks of volatility and to consequential higher demands for regulatory capital, it appears to me more likely than not that the claimant would not have taken out any more long-term swaps. And he refers to the 3 that already existed there. And he says these would have been recognised as giving rise to the risks of volatility and to consequential demands for regulatory capital. And so I think it more likely than not that the existing swaps would have been closed. So, but for the negligence, no swaps, no business model, no loss. The judge accepted that. That's why this is a loss. This is the basic loss in NICredit terms. Then we go on to page 167 and the heading Cause in Law. And in paragraph 140, the judge records my submission that the test on effective cause, legal causation, was whether the loss was sufficiently closely connected to the negligence. And in paragraph 141, Mr. Salcedo's submission that this was a common sense test. And then the judge...
I'm sorry, just going back for a moment to paragraph 124. Just to be sure I'm following this.
Yes.
The claimant's case is that but for the defendant's negligence, it wouldn't have entered into further swaps and would have closed out the swaps that it entered into before April 2006. And those were the 3 50-year swaps.
That's right, the 3 swaps that are identified in paragraph 127. So at the time that the April advice was given, the business model was in its infancy. The society had taken out 3 long-term swaps.
Yeah. It
had been advised at the end of 2005 that at that time it couldn't apply the hedge accounting rules. It wanted to do so. And what the judge accepted was that if it had been correctly advised in April 2006, that would have been the end to this business model. It would have been untenable because of the risks of volatility. So not only would the society not have taken on any more swaps and more mortgages, it would have closed out the swaps that it had already had. That's what the judge was finding there. Yeah. I hope that's clear.
Mm-hmm.
Thank you.
Why do you... All right, so fine. Okay, thank you.
Yes. So I've gone on to factual causation and then moved on to cause in law at paragraph, a heading at page 167. And I've showed you the judge recording the 2 rival submissions on the legal test, if they are rival. And then in paragraph 142, he sets out Mr. Harding's account of the reasons for closing down the swaps in 2013. My lord, this is the bit I promised you a moment ago, Mr. Harding's own account of the reasons for his actions. And he says, without hedge accounting, the society was required to recognise the exposure to fair value interest rate risk arising from the swaps in its income statement. This had 2 adverse effects upon the society going forward, over and above the loss sustained by recognising the fair value of the swaps in the income statement without a hedge offset. First, the profit and loss of the society, and therefore the capital reserves, became exposed to the full volatility of the mark-to-market value of the swaps as they changed over time. And he says that's dangerous. Secondly, exposure to these risks would mean that the PRA would require a greater level of capital to be held by the society to protect it against these risks. So those were the 2 points that I explained a moment ago. And so he says the society found itself with a greater capital requirement while simultaneously having lost a large amount of capital. And then the judge goes on in paragraph 143. It was because of the claimant sheet being exposed to volatility in 2013 that the claimant decided, with the encouragement of the regulator, to close out the swaps. So it wasn't because the swaps are loss-making. It's not because the swaps are out of the money. It's not because of the MTM value of the swaps. It's because the balance sheet is now exposed to volatility. Nothing to do with the intrinsic profitability of this business model. It's because the risk that the accountant has advised the society is not exposed to has in fact materialized. And that is why in paragraph 146, the judge concluded this paragraph by saying that to describe the defendant's negligence as merely the opportunity for the loss was, in his words 4 lines down, to seriously underplay the causative potency of the defendant's negligence. And he goes on to make the very point I've been labouring about volatility, that the use of hedge accounting was intended, as recognised by the defendant, to mitigate the effects of volatility. Once it was appreciated that hedge accounting was not available in 2013, the claimant's balance sheet was exposed to the full and unrestrained effects of volatility, and it was those effects which led to the claimant deciding to close down the swaps and thereby incur a substantial loss. And so he concludes that whether you call this sufficient connection or common sense, effective causation was made out. Then if we go on, please, to page 177. And to paragraph 177, you'll find the last of the judge's key findings, which I rely upon. So I said at an earlier stage that my 4 key findings were loss, but for causation, effective causation, and foreseeability. This paragraph is the last of those: foreseeability. Counsel for the claimant laid considerable emphasis upon the fact that the claimant had continued with its business of hedging its mortgages by interest rate swaps in reliance upon the advice of the defendant, and that the losses it sustained when breaking the swaps were the reasonably foreseeable consequence of the defendant's negligence. In this regard, support was found in the approach of Mr. Justice Tomlinson and Temseel. I accept that there was such reliance and that the losses were reasonably foreseeable. That's the finding of reliance and reasonable foreseeability. The judge then went on to consider Samco v. Holland, which is, of course, the subject of the appeal. Now, just pausing there, I do suggest that had MBS recounted those findings, but for loss reasonably foreseeable, effectively caused by the negligence, around the Temple in 1995, prior to the House of Lords decision in Samco, the society would have been advised unequivocally and universally that that established its right to damages. All of the prerequisites of contractual liability were made out. A breach of contract which caused the claimant to suffer a loss that it would not have done had the contract been properly performed, and which was the reasonably foreseeable consequence of the breach. So coming back to my points of law, the issue on the appeal is whether something further had to be proved. Lord Legate, yes.
I just wanted to ask before you come on to the law, was this what you call the basic loss ever quantified exactly? And presumably would have had to take into account, for example, the cost or benefit of closing out the 3 mortgages in 2006. Maybe other factors could have been brought in. Was there a figure for it?
Yes, all of these elements were quantified, and you see that through the judgment, yes. And the 32.7 million figure, I think, is a net one, but perhaps I'll check that with my juniors over the short adjournment and come back to you. But yes, absolutely. There were multiple flavours of expert evidence quantifying the position under the various assets and derivatives. Yes, Lord Sales.
Sorry, forgive me. Did the judge make any findings about the appreciation of Grant Thornton in relation to the regulatory position? Did Grant Thornton appreciate that their advice in relation to the hedging policy would, if not applicable, have the dramatic effects on the Society's regulatory position, which was what caused Mr. Harding to instruct that the swaps be closed out?
Yes, that was never an issue because it was accepted in the Grant Thornton witness statements. I'm going to give you a reference to that while my juniors just look and see if there's anything explicit in the judgment as well. But in the bundle, if I can take you first, please, to page 788. You'll see in paragraph 107 there, and sorry, I should say this, I've taken you to the witness statement of Mr. Nuttall, the engagement partner at the from 2006 through to 2009. And paragraph 107 of his witness statement set out our allegation about knowledge. So you'll see we made the allegation that my lord has referred to. And then in paragraph 108A, Mr. Nuttall says it was clear to me at all times that the application of hedge accounting could have an impact on the income statement of MBS. That was the reason why it was desirable from MBS's perspective to apply fair value hedge accounting to minimise potential volatility. I also appreciated that the application of hedge accounting would have an effect on the capital reserves. And he ends by saying, I also knew that there was a potential impact on MBS's levels of regulatory capital. Yeah, so that was his evidence. And then he was replaced in 2009 by Mr. Swales. And if you turn to page 790, just a couple of pages further on, the quotation at the top of page 790 is from the same paragraph of our amended particulars of claim. And in paragraph 51, Mr. Swale says that he agrees as a matter of principle that it's clear that ultimately the complete removal of hedge accounting will have an impact on the income statement, volatility, capital reserves, and by extrapolation on levels of regulatory capital. So that was the evidence before the judge. There are some passages from the cross-examination in this hearing bundle in which I explored that a little further. But it is my submission that that is the evidence that lies behind the judge's finding. unreasonable foreseeability, which I showed you at paragraph 177, but we will just check whether we don't think anything more specific than that was said.
Yes, thank you very much.
Yes, Lord Byron.
Yes.
Yes. Can I just, to get my own mind clear, take you back to the submission that you just made, that this has nothing to do with the profitability of the business. So as I understand it, what you're submitting is that this is not a case of a claimant who has made a bad investment type decision. There were gains being made and there were losses being made, and this was all part, the gains were being offset by losses, but it was all hedged. Any loss would be hedged. So that you can't say, in looking at this, that there was a bad investment decision or a bad financial strategy by the building society. It was simply down to the advice that they were getting from the accountants as to how they could present these in the accounts. It had nothing to do with the financial crash and losing out in that respect. Is that the submission?
Yes, it is, my lord. Now, Mr. Sarcedo is going to get to his feet virtually and say, but the judge made no findings about that. To which my response is, the judge found that my client suffered, and the Grant Thornton's client suffered a but-for loss of 32.7 million. That's the basic loss. And it was for his clients to establish that this was a bad bargain if they wanted to do so. But that inquiry would have nothing at all to do with the loss that my client suffered. It's an apples and pears comparison, and I can push that one too far. I proved the apple, I didn't have to prove the pear.
You say that the judge made no findings on this, but if you look at paragraph 175, which is, I think, on page 176, if you look at paragraph 175, you'll see it seems to me to be making the opposite point from the one that you're missing. He's setting out what he said is a cogent argument, and in particular, what is it, 7 lines down, 8 lines down, a sentence beginning second. Second, although hedge accounting had the effect of protecting the claimant's published profit and capital, and in particular its regulatory capital, from changes in the fair value of the swaps. So it had the effect of protecting the published account from changes in fair value. Such changes were nevertheless real and exposed the claimant to the risk of considerable loss, notwithstanding the application of hedge accounting. It was because of such changes that the claimant had a flux collateral, and that the regulator feared that a counterparty might exercise its right to terminate the swap. That risk of loss came about by reason of the risk that interest rates might fall, as they in fact did after the financial crisis. It goes on to make the point that find that the defendant wasn't assuming responsibility for the risk of such a loss, and says in the final sentence that although the apparent availability of hedge accounting enabled the claimant to make use of it, the decision of whether or not to use them was one for the building society, depending on its assessment of the commercial wisdom of doing so.
Yes. But what the judge
he's saying the focus on the accounts is wrong. That's the wrong thing to focus on. You should be focusing on the reality here. The reality is that this was a loss-making investment.
This wasn't an investment itself. The swap was to facilitate the mortgage lending. And what the table in our in our case, paragraph 31.11 shows you, is the effectiveness of the business model during the years 2006 to 2013. Very small movements either way. It was an effective business model. It was effective in real terms, and Grant Thornton's advice was that it was effective in accounting terms. What the judge is dealing with in paragraph 175 is the movement in fair value of the swaps. But so long as hedge accounting applied, in the books that would be offset by the hedge adjustment, and in reality, it would be offset by the mortgage income. So, my lord, the judge wasn't making any finding there about the profitability of the arrows diagram in the years 2006 to 2013. And he certainly wasn't making any finding there about what the profitability of that arrows diagram would have been in the future. All that he was saying, and of course he was right about this, is that the fair value in a swap will vary over time. And if you own a swap, you're exposed to that in the sense that you hold it. But that was part of the business model. He certainly wasn't saying there that the society was making losses because it held the swap. They weren't. That would be wrong. Yes, Lord Leggett.
You can put it a bit higher than that, can't you? Because you can show the accounts show that the society is apparently profitable. So
yes,
it does tend to suggest that at least had the hedge accounting been acceptable, it was bringing in more money than it was paying out year after year.
Yes, indeed. Well, the accounts showed the society profitable overall, and the figures within the notes, which are those extracted at the table at paragraph 31.11, are the profitability of the hedge accounting arrangement. So I'm happy to answer any more questions about the mortgage arrangement. Yes, Lord Hodge.
In your table at page 38, you show hedge adjustments of over 30 million pounds. And that would indirectly, presumably, be reflected in the capital value of the mortgages that you eventually had to sell or sought to sell. Would that be right?
The value of the mortgages will, of course, be affected by interest rates at the time that you sell them, but I'm not sure that I can assist any further than that in the correlation.
Well, let me ask another question then. They were marketed, and the par that was being sought was the money lent plus, I think it was described as rolled up interest. Is that
yes.
Right?
Yes.
What was that rolled up interest?
Oh, that was the fixed rate interest under the mortgages. So the mortgages were, for example, many of them were at 6.8%. So it was the rolled up interest. So under these mortgages, no interest payments had to be made until redemption. That's the way the equity release mortgage is made. So the holder would obtain the money against the value of their home, and the whole amount of the interest is then repayable upon the redemption, which is normally on the death of the holder.
So it's the rolled up interest, which is the interest which is to be paid on the death of the holder, but it's only rolling up what has been accrued from the date that the mortgage was taken out to the date of the sale.
That's what the rolled up interest refers to.
Was there an element in the sale for the enhanced value of the mortgage by reference to the differential between the interest rate being earned on the mortgage and the prevailing rates?
I'm afraid I don't know the answer to that question. I can take instructions on it.
No, because absent that actual increase in value, then in the real world, this business model was a dangerous one.
Yeah.
Well, my lord, to the extent it was a dangerous business model, that was taken into account by the judge's assessment of contributory negligence. The dangers were precisely what led the judge to determine that any award of damages should be subject to a 50% deduction.
Wasn't that relating to the fact that there was a mismatch between the swaps and the mortgages in question? I'm making a slightly different point, that the value of the mortgages don't appear to have reflected the element of hedge adjustment that the accounts were saying would exist.
Well,
and none of
it's maybe my fault. I'm not sure I understand the point there, because so long as the model continues, the actual payments being made are those set out on the arrows diagram, which cancel each other out. And so long as hedge accounting is being applied, the adjustment is made in the books, which deals with the problem of volatility and regulatory capital, and is indeed extremely effective even in 2008 and 2009 after financial turmoil. That's what you see from table 31, the table at paragraph 31.11. So neither at a real level nor at an accounting level is there a loss or a danger for so long as the business model can prevail. There is a danger inherent in having swaps and mortgages which are not of the same duration. That's the mismatch point. That's what the judge did take into account in his assessment of contributory negligence.
No, but you are claiming £32 million, which is the deficit, as it were, on the swaps arrangement. And I was just trying to probe what on the other side of the balance you obtained in relation to the value of the mortgages, which you had to crystallize at the same time.
Was it not 3 million?
Yes, so the mortgages were sold as, I will take instructions and make sure that I get this exactly right over lunchtime, but my answer at the moment is that the sale of the mortgages reflect the value of the interest rate, the fixed interest rates under that mortgage. But I'm now going beyond anything in the judgment, and I want to take instructions to make sure that
I just wanted to understand, because you are portraying the matter that everything was plain sailing at up to 2013, but we know that the regulators were worried that your model, on the judge's findings, your model exposed you to a high degree of risk.
Yes, but actually what the regulator...
I was just wanting to find out if this was part of the element of risk that the regulators were identifying.
Oh, I see. No, what the regulator was principally concerned about was actually the risk that the counterparties might break the swaps.
I see. Thank you. Thank you.
So let me come on to the arguments of law. I'm going to develop 6 points, and I'm going to tell you briefly what they are and then come on to develop them. So my first submission is that the problem that Samco was addressing was one of legal causation, where the breach of duty is one of 2 but-for causes. To what extent, if at all, is the defendant to be regarded as a matter of law as the cause of the loss? Second, the concept of scope of duty does not of itself answer questions of causation such as these in a contractual situation. Scope of duty is about what you have to do and who you owe the obligation to. And in a contractual context like this, that's straightforward. Grant Thornton's obligation was to perform the obligations set out in their contracts of retainer. Third, what a focus on the scope or nature of the defendant's duty does, however, facilitate is a structured analysis of issues of causation. You start by identifying what the defendant had to do, and then you ask the question, did the right thing cause the loss? In other words, did the breach cause the loss? Fourthly, there's no rule of law that question, did the right thing cause the loss, must be answered by asking what would have happened if the information had been correct. The Samco inquiry is merely a tool which may assist in answering, did the right thing cause the loss, in a case where the defendant's obligations and the breach lie within narrow confines. But it isn't a rule of law of itself, and it doesn't impose necessary obligations of proof on the claimant in the way that the Court of Appeal suggested. Come back to the point that the real test, and what does have to be proved by the claimant, is that the loss was sufficiently closely connected to the breach to be regarded as caused by it as a matter of law. Fifthly, and I come here to our narrow case, even in a case in which Lord Hoffman's information analysis is applicable or assists, a claimant does not have to prove the negative, that it would not have suffered a loss in an equivalent amount through some other route if information provided by a claimant had been correct. That goes beyond anything said in Samco and is wrong because the burden of proof is on a contract-breaking defendant who wants to prove that a claimant has entered a bad bargain. Sixthly, audit cases are not some special category of their own with some special rule of law, but they do demonstrate that the prior submissions are right because they demonstrate that it is impossible to apply Samco as a rule of law of general application, and it is often nonsensical to require a claimant to prove that it would not have suffered the same loss through some other route. With the exception of the present case, audit cases have strikingly not applied the Samco cap. So that's a map to the submissions I want to make. So my first point then, that the problem that Samco was addressing was one of legal causation. And can we go please now to Samco itself, which is at page 1308 of the bundle. Or rather, I would like please to turn up page 1308 of the bundle. So at page 210 of the report by letter C, Lord Hoffman identified the issue on the appeal. And he says that the three appeals raise a common question of principle. And he says that that is the extent of the liability of a valuer who's provided a lender with a negligent overvaluation of the property offered as security for the loan. And he points to the common features of the cases, that the lender wouldn't have lent if he'd known the true value of the property. And secondly, that a fall in the property market after the date of valuation greatly increased the loss. You'll see there straight away that when he refers to the question of principle, he frames that in terms of valuers' cases, valuers' negligence cases. He's not suggesting at the start there that the question of principle raised by the appeal before him it is a universal one. Then he came on, of course, to make his example of the mountaineer and the mountaineer's knee. And if you go, please, to page 1311 of our bundle, letter E on page 213 of the report, Lord Hoffman says, on the Court of Appeal's principle, the doctor's responsible for the injury suffered by the engineer because it's damage which would not have occurred if he'd been given correct information. But then he goes on to say, on what I've suggested is the more usual principle, the doctor is not liable. The injury has not been caused by the doctor's bad advice because it would have occurred even if the advice had been correct. So Lord Hoffman was himself there putting the position in terms of whether the loss has been caused by the right thing. If you go back to the prior page at 13, sorry, wrong way, on to the next page, 1312 of the bundle. And to page 214B, letter B, he says that the Court of Appeal's principle offends common sense because it makes the doctor responsible for consequences which, though in general terms foreseeable, do not appear to have a sufficient causal connection with the subject matter of the duty. So he was there putting the connection in terms of sufficiency of cause. At the bottom of that same page, he went on to refer to the House of Lords decision in Bank Kaiser Ullman and Scandia. And as he himself records at the top of page 215, 3 lines down, that was a case in which Lord Templeman had dealt with the matter in terms of causation. And so, my lords, we say that the point at the principle at the heart of the analysis in Samco is one of sufficiency of causation. And in my submissions today, I'm going to go on picking up that language of causation throughout the cases. Now, I am conscious in making that submission that in BPE, Lord Sumption said that Samco has nothing to do with causation as that expression is ordinarily understood in the law. But I suggest that he was there referring to but for causation, because as we shall see, he himself went on to pose the question, did the right thing cause the loss? I'm also conscious that Lord Hoffman's speech in Samco has sometimes been regarded as an expression of the rule on remoteness of damage, most notably by Lord Hoffman himself in the Achilles. I'm not proposing to join the fray, at least on this occasion, on whether assumption of responsibility is the right concept in regards to remoteness of damage. It doesn't matter for the purpose of my current submissions. But my point here is that in Samco itself, the discussion was in terms of the sufficiency of the causal link between the negligence and the loss. And we say that that is the issue with which this appeal is concerned too. I'm also going to give you one more reference, which is to page 2171 of the electronic bundle, to a 2005 article in the Law Quarterly Review by Lord Hoffman himself, in which he discussed Samco as a case concerning what should count as a sufficient causal connection. Now, staying with Samco, I'm going to move on to my second point, which is that the concept of scope of duty does not of itself answer questions of causation, such as these, of effective cause, in a situation such as the present. Now, if we go back, please, to page 212 of the report, which is at page 1310 of the bundle, you'll see that at letter C, Lord Hoffman posed what he characterised as the real question, being the kind of loss in respect of which the duty was owed. And he asks then, how is the scope of duty determined? And first he refers to statutory duty, then he refers to tort, and then 4 lines down, he refers to implied contractual duty. But what he doesn't do is address a situation such as the present when there are express contractual obligations. What a party to a contract, a written contract, has to do is perform the express contractual obligations. Now, I accept, of course, that Grant Thornton can only be held liable within the scope of their duty, in the sense that they can only be held liable for the consequences of the things that they undertook to do. They had to do what they'd contracted to do. They should only be held liable for failing to do what they'd contracted to do. But the concept of scope of duty in this context doesn't take you any further of itself. This is a different scenario from the situation in the tort of negligence, where scope of duty has classically been used to delineate the extent of a defendant's obligations with regard to who a duty is owed to, or what type of damage a duty is owed in respect of. So the cases that deal with pure economic loss, psychiatric damage, cases like Caparo and Dickman, which ask the question, do you owe a duty to me? And if you do owe me a duty at all, what's the duty to me compose? We're not here concerned with those questions. Grant Thornton had to do what they contracted to do. Nonetheless, Samco was itself a case in which the valuer owed express contractual obligations to the lender, its client bank. The novelty of Samco was to take the tort concept of scope of duty and apply it to issues of causation arising in a contractual case such as this. What Lord Hoffman was not purporting to do in our submission, by doing so, was to change the law, change the gateways for contractual liability, the legal filters that apply in a contractual case. And I say that first because at page 214, at letter C, Lord Hoffman introduced his discussion about information advice by saying, I think that one can to some extent generalize the principle upon which this response depends. That's the response to the mountaineer. He wasn't purporting to lay down a codified rule that would apply in every situation. Similarly, and we'll turn this up later, Lord Sumption in Samco referred to the Samco cap as simply a tool. In Anico, at paragraph 13, Lord Lloyd criticised the brokers for stating the Samco cap as if it were a rule of general application. So this isn't said in Samco to be a new and codified rule of law, and it has been said by the Supreme Court in BPE and the House of Lords not to be. And that's not just a proposition that it's not of universal application. In the Court of Appeal's recent decision in Asset Co, the court actually said that the test would be jettisoned where it was incapable of producing a fair result. We'll come back to that case too.
So come back to it after the short segment.
We can. I'm so sorry. I'm getting carried away, but that's the most convenient point as I'm just coming to point 3. Thank you.
Very well. We'll adjourn now and resume at 2 o'clock. Thank you very much.
Thank you.